To other news, and the International Court of Justice has ruled that it is within its jurisdiction to decide a case between Kenya and Somalia, despite a standing memorandum of understanding between the two nations. The maritime border dispute is over an oil-rich section of the Indian Ocean both countries want to lay claim to. The ruling now means Somalia's suit against Kenya can proceed, and Kenya will have to prepare her defense.
It was a mixed bag of answers for Kenya as the court dismissed Kenya's contention that it did not have the powers to hear the matter of the maritime dispute. But Kenya's consolation was the court's ruling that affirmed that indeed the memorandum of understanding between Kenya and Somalia stood. The ruling now means that if Somalia wishes to pursue the matter further, she can still apply to the same court, and Kenya would have to put up a defense in the tussle over the Indian Ocean territory. Despite having been signed, the MOU was subject of great debate in Somalia and was rejected by the Somalian parliament. Somalia had also earlier claimed that the minister who represented the nation was not authorized to go into any such understanding on its behalf.
The optional clause declarations of the parties constitute an agreement reached otherwise to settle in this court disputes concerning interpretation or application of one clause, and the procedure before this court shall thus apply in lieu of procedures provided for in Section 2 of Part 15.
It is on this basis that Somali government was pushing to have the ICJ resolve the dispute and ignore her previous agreement with Kenya. Kenya, on the other hand, held that owing to the MOU that she deemed valid, the court could not intervene in the matter as per international law. The ICJ favored this overview, stating that the two nations were properly represented in the signing of the MOU. Somalia's signature therefore expressed consent that the two would resolve the matter between themselves, and that the treaty had come into full force upon its signing in the year 2009.
In lieu of procedures provided for in Section 2 of Part 15, even when such declarations contained a reservation to the same effect as that of Kenya. The contrary interpretation would mean that by ratifying a treaty which gives priority to agreed procedures resulting from optional clause declarations, pursuant to Article 282 of UNCLOS, states would have achieved precisely the opposite outcome, giving priority instead to the procedures contained in Section 2 of Part 15.
So what next for Kenya? In a statement, the Office of the Attorney General has said that it will vigorously prosecute her case before the court and still extend the hand of friendship to Somalia with the view of achieving and negotiating solutions that alone can resolve the many challenges facing both countries. Trix Ingado, KTN News, Nairobi.